Okay, let's get back to this. The Oklahoma Open Records Act, um, in conformance with Title 51, Section 24A1, Oklahoma Statutes 1985, titled Oklahoma Records Act, all open records of the Real Estate Commission may be inspected and copied in accordance with procedures, policies, and a fee as required by the Commission. The Commission shall charge as the following. And it gives you a list of fees for copies. So like for a bunch of copies or whatever, you can pay like $50 every 3 months for an examinee data extract, shit like that, or 25 cents for each copy off a copier. Okay? Now we have this. It says Contract Forms Committee, and there's a little test question by both of these. I don't remember seeing this on the test, but let's read it anyway. Contract Forms Committee. 1. The Contract Forms Committee is required to draft and revise real estate purchase and or lease contracts and any related addenda for standardization and use by real estate licensees. Okay? That's Title OS 858-208, parentheses 14. Okay? 2. The committee shall consist of 11 members. 3 members shall be appointed by the Oklahoma Real Estate Commission, and 3 more members shall be appointed by the Oklahoma Bar Association, and 5 members shall be appointed by the Oklahoma Association of Realtors. So that's 11, okay? 3 shall be appointed by the Oklahoma Commission. 3 more, 1, 2, 3, okay? So that's 6 right there. Shall be appointed by the Bar Association, and then 5 more shall be appointed by the Oklahoma Association of Realtors Incorporated. That is the contract form committees. Just remember that. 11 members, 3 from the commission, 3 from the Bar Association, and 3 from the Association of Realtors Incorporated. Okay? These are definitions. Okay? Under 605, advertising means all form of representation, promotion, and solicitation by any means of communication, including social networking. That means social media. Okay? A bona fide offer means an offer in writing. Branch office means an extension of a broker's main office location and normally is located at a different location than the main office. Okay? Branch office broker means a person who qualified for a broker's license and who is designated by a broker manager or proprietor broker to direct and supervise a branch office on behalf of the broker. A branch office broker is considered an associate of a broker manager or proprietor broker. Okay? Broker means a sole proprietor, corporation, managing corporate broker of the corporation, association, managing broker, member, or manager of an association, partnership, or managing partners of a partnership, and shall be one and the same as defined in the earlier section of broker. Okay? Whom the commission shall hold responsible for all actions of associates who are designated to said broker. I think that's the main part, that the broker is responsible for all actions of the associate who they manage. Okay? Code, when used in the rules of this chapter, means Title 59, Section 858-101, Oklahoma Statutes as adopted 1974 and amended. Okay, entity means association, corporation, and partnership. Filed means the date the United States Postal Service postmark, or the date personal delivery is made to the commission office. Firm means sole proprietor, corporation, association, or partnership. Inactive status means a period in which a licensee is prohibited from performing activities which require an active license. Non-resident means a person who is licensed to practice in this state, however, does not maintain a place of business in this state, but maintains a place of business in another state, and who periodically comes to this state to operate and perform real estate activities. Previously licensed applicant means a person who has been licensed in another state and desires to obtain a resident license in this state, like what you're going to do with Arizona as soon as you pass this. Okay? Provisional sales associate shall be synonymous in meaning with a sales associate, except where it's specifically addressed in other subchapters. Okay? Rents or leases real estate. Okay? Means the license activities provided by a broker through a property management agreement with a party for a fee, commission, or other valuable consideration. Okay? Licensed property management activities may include showing real property for rent or lease, soliciting tenants and landlords, negotiating on behalf of the tenant or landlord, and complying with and maintaining the property in accordance with Title 41. Team name, okay, means a name used by a team as defined in 858-305. All team names must be approved by the broker and must be registered with the commission. Trade name means the name. Trade name means the name a firm is to be known as, and which is used in advertising by the firm to promote and generate publicity for the firm. Publicity for the firm. Okay, so I want to, hold on. Oh, shit. Section. They keep referencing Title 59. I don't know where Title 59 is. I wonder if it's up here. Because there was some stuff right here. Yeah, I don't see anything with that on it. I think all my stuff got mixed up. When I went down there to take the test. And I put all my stuff, I put all the stuff I was supposed to learn behind the wrong section. See, that's all week 1. This is week 2. These are actually test questions in here that I want to go over and read and record, and maybe they would be helpful, but there has to be an answer key with them. I think there might be one. Yep, here's an answer key here. That wasn't the answer key for 1. Here's the answer key for 1. 1 and 2. Here's the answer key for all of that. So we're gonna go over that later, but I'm just yeah. See, she didn't say to go over any of that, so anyway, okay. Okay, Here's 60510-3-5 examinations. Applicant must appear in person. When an application for examination has been submitted to the commission, the applicant shall be required to appear in person at a time and place to be designated by the commission and answer questions based on the required subject matter as prescribed elsewhere in the rules of this chapter. On and after August 1st, 2001, each broker examination fee, it shall be $75, and each provisional sales associate examination fee shall be $60. In cases where special accommodations are necessary under the requirements of the Americans with Disabilities Act, applicants must notify the examination supplier in advance by submitting a written request on a form prescribed by the commission describing the disability and necessary accommodations. Okay, failure to pass examination. If an applicant fails to pass the examination prescribed by the commission may permit subsequent examinations upon receipt of a new examination fee for each examination to be attempted. So if you fail the first time or the first couple times, you can take it again, but you're going to have to pay each time. Except for Angela's. You can take that as many times as you need until you pass for free. Okay? D, applicant requests to view failed examination. An applicant who fails the examination has the option of reviewing their missed questions at the end of their examination. An applicant may challenge the validity of any question they identify as incorrectly graded. A challenge to a question that pertains to the Oklahoma law portion of the examination will be sent to the commission by the examination supplier. A challenge to a question that pertains to the national portion will fall under the review policy for examination supplier. So you can protest your failed questions and they can put it under review and, they'll put it under review and see. Applicants will be allowed 1 hour to review their exam, and the applicant will not be allowed to test on the same day they review their failed examination. No notes, pencils, or electronic devices will be allowed during a review, nor will they be allowed to leave the examination area with the examination questions. Okay. Application valid for 1 year. The original examination application shall be valid for 1 year from date of filing. After such date, an applicant must complete a new original application form. Passing percentile of examination. A score of 75% or more shall be considered passing grade for the broker examination. A score of 70% or more shall be considered a passing grade on the provisional sales associate examination. So you only need 70%. So had that been the test at the state, you would have passed because you only missed one question. So let that motivate you just a little bit. I mean, you only missed it by one question. It means you know what you mean. Okay, required number of continuing education hours. We know this. The required number of continuing education hours for a licensee shall be as followed. Okay. You have to have completion of 21 clock hours of the commission-approved subject matter or its equivalent as determined by the commission. Each licensee shall have completed a said 21 clock hours of continuing education and 6 clock hours of required subject matter as directed by the commission. So this is after you pass. Okay, you have to have this is after you pass and after you get licensed. You have to have 21 hours continuing education and 6 clock hours of required, okay? The required subject matter or its equivalent as determined by the commission shall consist of at least 1 clock hour in all the following subjects, okay? You have to learn professional conduct, Brokers Relationship Act, fair housing contracts and forms, code and rule updates, and current issues. The remaining 15 clock hours may consist of elective subject matter. So that means just any subject matter of your choosing, I think, because what's an elective in high school? It's, you get to choose it. Okay? So that guy on YouTube already went through this, but he didn't really go through the Brokers Relationship Act, which pissed me off. Okay, recruitment disallowed. So that means that when you're in class or when a teacher is teaching, they can't recruit students in the class to come work for them, for their firm. Like Angela can't go and pick out students in the class and say, hey, you should come work for Remax. So they can't do that. Okay? Here we go. Student must successfully complete a pre-license, post-license, or distance education course offering an examination in order for an entity to certify a student as passing an approved pre-license, post-license, or distance education course. The student must successfully complete an examination covering the contents of the course material. Expiration date. The actual expiration date of a license shall be midnight of the last day of the month of the designated license term. A person who allows their license to expire may be subject to a national criminal history check as defined in section 150.9 of Title 74 of the Oklahoma statutes. Okay, so we knew that one. If your license has lapsed more than 1 year, you have a fee, a reinstatement fee, and the documents as required by the commission. So don't let your license lapse, because then you just have all this bullshit to go through, okay? Lapse more than 1 year, but less than 3 years. You have a license fee, a reinstatement fee, a national criminal history check, a completed reinstatement application. You have to have successful completion of the appropriate licensing examination, a statement that the applicant has read a current license code and rules, documents as they may be required by the commission, and then, so that's all a bunch of bullshit. So don't let your license lapse is the point there. Okay, licensee on active duty as a member of the armed services, you know about that. They get extra stuff because they're in the military and they can't be around all the time to do certain stuff. Okay, name change, you know about the name change. It's 10 days of a name change. Each additional office must be licensed. If a broker desires to do business from more than one office location, the broker must license each additional office location as a branch office by submitting forms and fees as required by the commission. The licensee shall be maintained in the branch office and available upon request. Okay? Associate's license issuance. An associate's license shall be issued electronically and maintained in the associate's license portal under the supervision of the branch broker and managing broker. Broker to designate a branch office. Broker to act. Okay? A broker shall designate a branch office broker, other than himself or herself, to act as a broker for each location, to supervise the activities of the branch office. The branch office shall be licensed in conformance with Section 858-310. The branch office broker may be designated to perform all duties and sign documents on behalf of the broker with respect to the branch office at the discretion of the broker. Such designation shall be in writing and filed with the commission. The branch office broker assumes the responsibilities in conjunction with the broker for all associates assigned to the branch office. Broker may act as a branch office broker. And it says restriction. A broker may act as a branch office broker if the branch office is located at the same location as the main office upon the appropriate documents and fees being filed with the commission. Okay, and then it says branch office must utilize the same name and trade name of the main office. A branch office may utilize a trade name which is different than the main office, so long as the broker registers the name with the commission. This commission seems to be a fucking pain in the ass, is what it seems to be to me. Okay. Says read through here. Non-resident licensing. This is a non-resident applicant may apply to the commission for a license to operate as a non-resident by submitting all appropriate documents as required by the commission and furnish evidence that the applicant possesses a current active license in the applicant's resident jurisdiction. Okay? A non-resident applicant who has been actively licensed as a sales associate or broker, respectively, for a minimum of 2 years out of the previous 5 years. Okay. Then we have co-brokerage arrangements. A broker of this jurisdiction may participate in cooperative broker arrangements with a broker of another jurisdiction, provided that each broker conducts real estate activities only in the jurisdiction in which they are licensed. Request for license transfer. In the event a non-resident Oklahoma licensee desires to transfer the license and obtain a resident Oklahoma license, or desires to transfer the license to another jurisdiction, the non-resident licensee shall be required to meet all applicable requirements and pay the appropriate change of address fee and submit all appropriate documents as required by the commission. In the event a resident Oklahoma licensee desires to transfer the license and obtain a non-resident Oklahoma license, is this just repeating it? The licensee shall be required to pay the appropriate change of address fee and complete and submit all appropriate documents as required by the commission. Okay, here we go. Okay, this has a little note that says important. Place of business. Each broker shall maintain a specific place of business and supervise a brokerage practice which is available to the public during reasonable business hours. Each broker shall be available to manage and supervise such brokerage practices and comply with the following. The place of business shall consist of at least one enclosed room or building of stationary construction wherein negotiations and closing of real estate transaction of others may be conducted and carried on with privacy, and wherein the broker's books, records, and files pertaining to real estate transactions of others are maintained. 2. Each broker shall register for each place of business a physical business address and office telephone number. Okay? Now we're under branch offices. If a broker maintains one or more places of business, the additional places of business shall be referred to as a branch office. Office located at residence. The office may be in the residence of a broker. Associates not permitted to have an office. Okay? Associates are not permitted to have a place of business, but must be registered with a place of business, maintained and registered in the name of the broker. Licenses issued to a place of business. All licenses will be issued electronically to each licensee in the individual license portal. Broker may be broker for more than one firm. Okay, broker may be a broker for more than one firm. A broker may be a broker for more than one firm so long as the firms are at the same location. Okay, that makes sense. Broker is responsible for acts of unlicensed assistance. A broker is responsible for all the real estate related activities of an unlicensed assistant working within the firm. Office identification sign. Each licensed real estate broker holding an active license certificate, except those registered as being associated with a broker who is in compliance with this section, shall erect and maintain a sign on or about the entrance of his or her office and all branch offices, which sign shall be easily observed and read by persons about to enter any of said offices. Specification of the sign. Each sign shall contain the name of the broker or trade name registered with the commission, and if a partnership, association, or corporation shall contain the name or trade name of such firm, the sign must indicate that the party is a real estate broker and not a private party, to include but not limited to company, realty, or real estate, as the case may be, all in letters less than 1 inch in height. Legal abbreviations following the trade name or name under which the broker is licensed shall be acceptable as long as they are more easily identifiable by the public as such. Okay? Each licensed broker or entity may register in writing to the commission all trade names used in connection with real estate activities prior to the trade name being advertised or displayed in any way. Further, each broker is to notify the commission in writing of all deleted, unused trade names. The registration of each trade name must be accompanied by a $10 registration fee. You have to register your trade name. A broker shall register you have to register your team name. The broker shall register each team within brokerage with the commission on a form prescribed by the commission. The fee for each team name registration shall be $100. Jesus. Each team name must be approved by the broker and must be unique and not registered to another real estate team within the state of Oklahoma, and must be identical to any association, corporation, or partnership license. Must not be identical, to any association, corporation, or partnership licensed as a real estate entity by the commission. The broker shall not allow any team name identical to an associates corporation or association formed for the purpose of receiving compensation. I know this is long, just hang in there. Let's get through this. Each team name must be registered to the commission prior to the performance of any licensable, I don't know how to say that, licensable activities by the team. It shall be prohibited for a broker to register any team name that is not being used by a team within their brokerage. The broker shall maintain and keep a current list of teams and their respective members in writing within the brokerage. Copies of this list shall be made available immediately to the commission upon request. The broker shall notify the commission in writing of all deleted or unused team names. Team members must maintain an active Oklahoma real estate license. Okay, now we're in a section on advertisements, and it says right here, says many questions on this. Okay, so let's see. Requirements and prohibitions. I don't know how to say that. A broker, when advertising, must use their registered business trade name or the name under which the broker is licensed. Include the broker's office telephone number. Okay. A broker, when operating under a franchise name, shall clearly reveal in all office identification and in all advertising the franchisee's name along with the name of the broker or business trade name as registered with the commission. A licensee shall not advertise, rent, or lease property when such advertisement is directed at or referred to persons of a particular race, color, creed, religion, national origin, familial status, or handicap. and must be confined to information relative to the property itself. We know about that. Any advertising in any media which is misleading or inaccurate in any material fact or in any way misrepresents any property, terms, values, services, or policies is prohibited. A licensee shall not advertise any property for sale, rent, lease, or exchange in any media unless the broker has first secured the permission of the owner. Social networking. A licensee who is engaged in license activities through social networking mediums must indicate their license status and include their broker's reference as required elsewhere in this rule. A licensee shall not use a yard sign at the licensee's personal residence as a marketing tool to make it appear the real property is for sale. Yeah, you can't advertise in your front yard because then people are going to think your house is for sale. Okay? A broker may authorize an associate to promote a seller incentive with the consent of the seller. Associates advertising. An associate is prohibited from advertising under only the associate's name. We know that. Must be under the direct supervision of the associate's broker. The associate must include the name of the associate's broker or the name under which the broker operates. Broker's reference is prominent, easily identifiable. The broker's reference shall be at least 50% or larger than the associate's reference. We knew that. The associate's personal insignia, of which such approval is to be maintained by the broker, cannot be construed as that of the firm's name. The associate's personal nickname or alias, which must be registered at the commission prior to its use. An associate's contact information. A slogan which cannot be construed as that of the firm's name. A domain website name that is registered with the broker. The broker's reference shall appear on every individual page or frame. Open house or directional signs used in conjunction with the broker signs do not have to contain the name or trade name of the associate's broker and broker's telephone number. So if you're doing an open house, you don't have to include the broker's information. Only in open house or directional signs, okay? That's the only time you can do that. Okay. Broker change of address or telephone number. Any change of business address or office telephone number of a broker must be filed in the commission's office within 10 days of such change. It seems like if you're going to change anything, it has to be notified. You have to notify the commission within 10 days. Filed shall mean the date of the United States Postal Service postmark or the date of personal delivery is made. Okay, broker shall return his or her certificate to the commission along with those of all licensees. Death or disability of a broker. Okay, in the case of a sole proprietor, all brokerage activities must cease and a family attorney or representative should perform the following. Notify the commission in writing of the date of death or disability. Advise the commission as to the location where records will be stored. Return the broker's license certificate and pocket identification card and all license certificates of those associated with the broker to the commission. Notify each listing and management client in writing that the broker is no longer in business. Notify each party and co-broker to any existing contracts. Associates licensees, license issuance and change request. Each associate license shall be issued electronically to each associate through the individual license portal. I think I already mentioned that. The associate's new broker shall be required to provide consent to sponsor the associate with the commission. In the event a broker refuses for any reason to release an associate, the associate shall notify the broker in writing of the disassociation and furnish the commission with a sworn statement that the notification has been sent to the broker. Upon receipt by the commission of aforementioned statement, the commission shall release the licensee. Okay? Associates transfer. When an affiliated associate leaves a broker for whom the associate is acting, the broker shall make every attempt to notify the associate of the disassociation. A lot of hard words. Active associate may continually act. An active associate transferring from one broker to a new broker may continually act if the change is done in a timely manner and in compliance with the 10-day notification requirement. Compensation due a dissociated associate. A previous broker may pay compensation due a dissociated associate directly to the associate and not be required to make the payment through the associate's new broker. So if you're transferring or leaving that broker, he can just pay you. He doesn't have to send the money to the new broker for him to pay you. Okay? Okay, now we're in trust account procedures. This seems kind of important here. See, this was a test question right here. Record retention. A broker shall maintain all records and files for a minimum of 5 years. I think I accidentally put 10, so just remember that. A broker shall maintain all records and files for a minimum of 5 years. Okay, after consummation or termination of a transaction. In the case of trust account records, the 5 years shall commence with the date of dispersal of funds. Records as referenced in this paragraph shall be destroyed in a secure manner. Requirements for storage of records on alternative media. Alternative media is defined as media that is used as an electronic device to store or retrieve the information that pertains to the trust account and transaction documentation. This requirement applies to any computer technology utilized by the broker to create, store, retrieve aforementioned documentation. If a broker utilizes his own equipment or a third-party vendor to create, store, or retrieve this information, the broker shall ensure that the documentation is maintained and able to be retrieved for the 5-year time period as required for the commission. So, see, if we would have just got that answer right there, we would have passed. Trust account records shall be maintained by the broker in their original format for a minimum of 2 years. Okay, so trust account records shall be maintained by the broker in their original format for a minimum of 2 years. Minimum of 2 years, okay? And trust account records may then be transferred to alternative media for the remaining required record retention time. So, the record retention time, a broker shall maintain all records and files for a minimum of 5 years. Okay, but trust account records shall be maintained by the broker in their original format for a minimum of 2 years. So just remember that.